In this video, we'll be discussing about the theme of contract part 1. So Indian Contract Act 1872. So this will be a general discussion over the theme, and it is helpful for the purpose of understanding the bare act, understanding the law, understanding the theme, that what exactly is being wanted to be drafted and which is given to us in 1872 and still relevant. So contract, for the purpose of understanding, could be divided into two parts, part 1, part 2. Part 1 talks about fundamental and basic principles of contract. It runs from section 2 to section 75, and part 2 runs from section 124 to section 238. Parts have been repealed, which will be discussed in later videos, and this part deals with specific contract like contract of indemnity, contract of guarantee and others. Now part 1 could be further divided into 3 steps for the purpose of understanding. Step 1, that is formation of contract or fundamental of contract. The basic principles, very basic principles are mentioned here. Then step 2, performance of contract. Obviously, if a contract is formed, then there would be performance of it. And then the third step is breach of contract. So if no performance is there, then breach of contract would occur. However, there are other conditions that has been dealt in section 64 and 65, void contracts and voidable contracts accordingly. So step 1, formation of contract, runs from section 2 to section 72. So section 2 talks about definitions. Then chapter 1 talks about communication, acceptance and revocation, runs from section 3 to section 9. Then chapter 2, contracts, voidable contracts and void agreements. It runs from section 10 to section 30. Then chapter 3, contingent contracts, runs from section 31 to section 35. Then chapter 4, quasi contracts, runs from section 68 to section 72. Now one thing which has to be kept in mind throughout the time is that there can never be a scientific demarcation or scientific bifurcation of sections and chapters in a bare act. So do not look for that perfection. Then performance of contract, that is chapter 4, runs from section 37 to section 67. Then breach of contract, chapter 6, runs from section 73 to section 75. In order to understand the equation, in order to understand step 1, we can have this equation for step 1, and equation goes: proposal plus acceptance becomes agreement, and agreement when enforceable by law becomes contract. So proposal as defined in section 2A plus acceptance means when this proposal is accepted, section 2B, it becomes agreement, that is section 2E. And when this agreement is enforceable by law, which is mentioned in section 10, it becomes a contract, section 2H. Section 2H talks agreement enforceable by law are contract. Now section 10 talks about enforceable by law. It talks about 5 conditions which covers section 11 to section 30. It talks about 5 conditions. Every condition, if breached, has its own consequences, will be dealt in later videos. So first is capacity of parties. Parties are required to be competent in order to enter into a contract. Section 11 and Section 12 talks about this. Then free consent. The consent of the parties is required to be free in order to enter into a valid contract. So it runs from Section 13 to Section 22. Third condition is ingredient is, or better to say 5 ingredients of Section 10. Lawful object. Third ingredient is lawful object. Runs from Section 23 and 24. Then we have fourth ingredient, lawful consideration, Section 25. And last is not expressly declared to be void. These are the contracts which are specifically declared to be void. Section 26 to Section 30. One thing has to be remembered. All unlawful agreements are void, but all void agreements may not be unlawful. Reason being, these are specifically declared to be void.